Howdy, my name is Carl Dore. Welcome to the Trends and Traps for 2019 in the oil and gas services industry related to how to analyze and review and see exposure in the risk analysis world. That's what we do as attorneys. We're constantly evaluating and working with risk assessments between the credit management world and the general counsel's departments. How do those fit? How do they react? How do they handle their contracts, their reviews, their exposure? It's more than just what is the operational issues on a frac job. I'm stuck on the well and I can't get off safely and the guy's out of money. It's bigger and stranger today than that. But I think you're going to find it interesting. We have segments of virtually all the topics we could come up with that would fit your world and your interest today. Everything from how to use a petroleum engineer to analyze the complexities of the customer operator, to what do you do after a bankruptcy and they're trying to claw back and take your money back from you. I hope you enjoy it. Get ready. Thanks.
So my name is Lisa Carter. I have been in the oil field services industry since about 2005. Kind of wandered into it after a military career and a career as an employment lawyer. And eventually, in about 2010, working with a man named Lonnie Hobbs, I got into MSAs. So I've only been doing MSAs since about 2010, but trial by fire at BJ Services, when we started the company again in January 1st of 2017, we had about $1.5 billion in revenue projected for that year, and we had 0 MSAs. So we got signed about 350 that year. Myself and 2 other lawyers, well, paralegal and a lawyer. And so we have seen everything there is to see, I think, in MSAs. We are now standing at about 600 signed MSAs with our customers. So a little bit of fast action at BJ. And I know that a lot of people, but let's just ask the room, how many people here have worked for BJ at one point or another? Oh my gosh. Well, thank you for your service. All right, and I'm talking today with one of Carl's young associates, Andrija Stanojcic. Did I say that right? Right. Okay. And Andrija got out of school in 2016 already knowing he wanted to do oil field services work. How about that? I mean, how many people knew that when they were in law school, right? Son of a petroleum engineer, so he kind of gets it. And he does commercial agreements, transactional work, and collection work. So he redlines a lot of MSAs, and you're going to see some of his work today in these slides. Some of the slides are wordy. Don't worry about it. You're going to get copies of those if you need them. They're examples of redlines. So we're not going to dwell on them, but we want you to know that we've seen it and we've redlined it. Okay? So what we're talking about today is how are the operators shifting it to us now, right? Because MSAs are all about risk. Are they shifting it to us? Oh yeah, in a lot of ways. So we're going to quickly go through some of the highlights of what you'd find in an MSA. For example, I don't know if we can fix this to land on the slide, but the first thing we want to talk about is something that credit and collections people really care about, and that is payment terms. In fact, I'm pretty sure my accounting department only cares about payment terms. So we've got some issues that we want to spot, and we've got some language that we want to show you. But I want to talk for a second about discounts for early payment. We've seen a lot of people offer us discounts for early payment. Do we want those? No. Not at BJ. We want all our money. Okay, so watch out for that. That can be in your language that they send you that they're gonna discount, X% for payment within 30 days. Heck no, we just want payment within 30 days, right? All right, and then fixed pricing. Sometimes you'll see in an MSA that they wanna say these terms are fixed pricing, or the attached pricing list will be fixed for 2 years or whatever. No, the MSA is not a place to put pricing. So let's just strike those every time, all right? Okay.
Yeah, so this is an example of some language or some provisions that show short deadlines for submitting invoices, long payment terms, and a 10% penalty basically on any overcharges or double invoicing once it's discovered and refunded. And throughout our presentation, just as a note, we'll problematic language, or language that you should be on the lookout for, is going to be bolded. So that's how we're going to kind of reference problematic language going forward.
There you go.
Yeah. So this is how we would maybe approach some, that problematic language that we highlighted in the previous slide. You can see here the green text is text that we would be suggestive language.
Green means go. Go for the green.
Green means go. Yeah, and so that gives you kind of an idea of how I would at least personally approach some of these problematic payment terms.
One of the things here, they say completion of work. You're going to pay within. We're going to invoice within completion of work. At BJ Services, I don't know about the rest of you guys, but we have trouble getting an invoice done, and we want to have that job accepted. And so we change that every time to acceptance by the customer. Some people don't have any trouble getting their work ticket signed, but when you do big frac jobs, you meet with the customer and you talk about everything, and then you submit an invoice. So we want that acceptance by the company. And what about that time bar? That is something that's pretty new. In the last couple of years, the other side, operators have been sending us MSAs with that time bar. Meaning you don't get paid at all. You can't get your act together, and sometimes they start with as little as 60 or 90 days. If you can't get your invoice together, you don't get any money, which seems ridiculously unfair. So we try to go as far out as we can. We tried for a year. 180 days, something, as big a period as we can. Then the other thing we try is, okay, instead of completely time barring the entire invoice, how about just a little haircut? And we've been successful getting just a haircut instead of a time bar complete to the invoice. So, try everything when you're negotiating. Okay, anything else? Okay. I need to point this somewhere else. I don't know where I need to point it. Oh, sorry about that. We had another example. Oh, right here.
Yeah, so this.
I did not do that on purpose.
So this is a good example of invoice dispute language that you would want to pay close attention to. Recently this has kind of become almost standard in most of the MSAs that I've encountered, whereby generally the company wants to have an invoice dispute language in there, but they want it to be as broadly written as possible. And so what you see is that they can just withhold payment of the dispute and pending resolution of the dispute. So they don't have to provide any explanation or reasoning for the dispute. There's no timeline for them to notify you that they're disputing it. So the better version, which you see the bottom half of the slide, is kind of how we would approach that, and it's just adding some language in there that makes it more equitable. Ideally, the operator should be required to at least provide you with written notice, detailing their dispute, and that notice should be provided ideally, once again, within a reasonable time frame. So maybe something like 15 days, within 15 days of their receipt of your invoice. But of course, not all of them agree to that, especially some of the bigger companies.
warranties. We care a lot about warranties because it determines what we're going to do when we mess up, and occasionally we mess up. So you really need to understand your company and what it does before you start writing a warranty. For example, I just helped a lightning protection service with a warranty, and we are disclaiming just about everything, and we're especially disclaiming lighting stuff. So, I mean, it's really important to know what your customer does before you start redlining the warranty provisions. But we've got some examples for you guys. Well, okay, go ahead.
Yeah, so this is an example of a warranty provision with some problematic language in there that basically requires the contractor to accept very broad liability for a breach of the warranty provision. And you can see that language where it says, "and all damages resulting therefrom." So it's not just remedying the defective or unsuitable work or goods. There's also problematic. Go back to slide. Yeah. Okay. This is it. Sorry. This language also does the same thing. It's problematic in the same way. It's trying to create a very broad scope of liability for a breach of warranty. There's also another area of problematic language here, which is the bottom part of this, and I've seen this in quite a few MSAs quite recently. It's language they'll try and stick in. Sometimes they stick it in a warranty provision like this. Other times it'll be a standalone provision somewhere. Basically, it says that the contractor is required to inspect company-provided materials and equipment used in the work, and identify a defect and notify a company of the defect. And if it doesn't, they're responsible for anything that may happen as a result of failure to do so. So that's something we definitely want to push back on whenever we encounter that.
And here's your.
And this slide would show how we would address the provision that you saw on the previous slide.
And the reason you want to do that really is because the other language turns your indemnities on their heads. I mean, it really does say, okay, now you're liable for everything just because you didn't find a defect. We don't want that. We don't want the indemnities to change. We want the knock for knock to stick just like it's supposed to. And so I usually get people to rewrite that when they understand the indemnity shift that it created.
Yeah, I think ideally you would want your warranties, your liability for a breach of the warranty to be limited to repair, replacement, or removal of the defective good or part of the work. Obviously, not every operator is going to accept that, especially some of the ones that have more bargaining power than others.
So this is an example. I went back a slide because where it says shall be removed, replaced, or corrected by contractor, this is a typical warranty provision, and it is one that we use at BJ. However, when you cement up a hole, the removal part of that equation can be really crazy. And so it's helpful if you're gonna agree to remove, if you know your customer and you know what they mess up, it's really helpful to have that limitation on the warranty. 100% of the ticket, 120% of the ticket, 150% of the ticket, doesn't matter. When you're in the cementing business, you need a limitation because removal can be a huge expense. On a $40,000 ticket, you don't want to be paying hundreds of thousands. And then this is an exclusion that you would want to have every time. No matter what warranties you give, you're going to want to sum it up by saying this is your only remedy. Right? Okay.
Yeah, so this is also another example of warranty limitation language that you would want to insert into every MSA. And basically what this does is expand on the other previous limitation that we saw, and specifies that you're not responsible for any failures of work or goods that were tampered with in any way other than by your authorized representatives, a failure due to the due to lack of the operator's compliance with recommended maintenance procedures if it's a tool or some other piece of equipment. And of course, anything that would require replacement due to normal wear and tear should be responsible for that. So.
Okay, let's talk about indemnities. The big one that I don't have a lot of explanation for that really is out there is the bigger operators are now requesting that we take what they call skin in the game. That we take some responsibility for simple negligence. Have you guys seen that? Are you dealing with that? I mean, Chevron, BHP, a bunch of them, and really, it's not really that you can negotiate your way out of them on those bigger companies. You really kind of have to negotiate what that number is. What is it that you can afford? The problem with that language, let's say it's in the catastrophic or in the pollution, it actually says for simple negligence, that we're going to indemnify them for the first $1 million or the first $10 million with Chevron or the first $5 million with others. That language, if you go back to your risk management and go to your insurance documents, your insurance has language that says you agree to contract out of simple negligence. And it almost says it that inartfully, right? And so you really, if you're going to have a contract with Chevron, which basically makes you negligent, makes you liable for simple, you got to go to your insurance company and say, can we have a waiver, please, on this one? So it's very complicated, and it's really not fun negotiating with those bigger companies. There are only about 5 that I'm aware of that require that, but it's something to very carefully watch out for. Different group definitions. A lot of times the operator will want to define their group very broadly and want to define very narrowly and define theirs very broadly, where, for example, we have to take responsibility for invitees, but they don't. I am usually successful at getting those made mutual, where, look, whatever your groups consist of, that's what we want our group to consist of. And I think that not only is that fair, but I think that's probably required by at least the Texas Anti-Indemnity Act would say if it's not going to be equal, then you might have a problem with mutuality. Knock-for-knock indemnities, we're going to look at those. The big thing that I see in the last couple of years is that they stop at knock-for-knock. They give you knock-for-knock, and then they don't put anything else in. Even the smaller companies, they're just, oh no, let's just strike all the rest of that. Let's strike catastrophic. Let's strike all of those things, pollution, and let's just leave it silent. That's not acceptable.
Can you explain the knock-for-knock in terms of what your context is compared to?
Yeah, I'm gonna let Andre explain that with a slide. We're gonna go through examples for downhole and rental and catastrophic. But the problem is that a lot of these contracts today don't have any of those in there. They just stop at knock-for-knock. Then we've got a slide on pollution and contamination, and then we have another sort of cats and dogs information. So let's let Andre go through knock-for-knock. I promise I'm just touching it once. There we go.
Yeah, so ideally, I think for most services companies, what you want to see is true knock-for-knock indemnity or a true reciprocal regardless of fault indemnity, which basically means that a company agrees that it's responsible for its own people and its own property, and you agree you're responsible for your own people and your own property, regardless of how damage to either of those things occurs, even if it's the sole negligence of the other party, even if it's the gross negligence of the other party. That would be a true, pure knock-for-knock indemnity, as I think is generally understood. And what we're encountering, or at least me personally, in a lot of MSAs is the, you'll read the provision, the indemnities. It appears that your indemnity of the operator is a knock-for-knock. Then you get to theirs where they're indemnifying you, and you start reading it, okay, it looks the same, knock-for-knock, but then you get to the end, and there's a carve. It says they're not required to indemnify you in instances of your gross negligence or willful misconduct. whereas you're still required to indemnify them for your losses, even if they were grossly negligent or engaged in willful misconduct. Sometimes they'll go even further. They'll say, for example, that they're not required to indemnify you in instances where you breached a contract or where you breached one of the warranty provisions in the agreement. So then that kind of really, as Lisa said, flips the whole thing on its head. It's not reciprocal anymore. It's not a true knock-for-knock indemnity, and that's problematic. And you definitely want to try and push back on that.
Oops. Sorry. There we go.
Yeah, so this is, you look at for the bolded language here. This is probably how I would approach, redlining this. We want to strike anything that we need to strike to return it back to a regardless of fault reciprocal indemnity. I left the gross negligence and willful misconduct in because, from my experience, especially with larger operators, they're just if they have this language in there, if they have this carve out in there, they're not going to let you strike gross negligence or willful misconduct.
But wouldn't you put it back in on there so that it's mutual?
Absolutely, yes, yeah, that's a great point. Yeah, you want to make it mutual, so you can say, okay, fine, you don't have to indemnify us if we're grossly negligent, but with respect to our own equipment and personnel, if you're grossly negligent, then you could be held liable.
So then we're just going to run through some missing clauses, and these are going to be in your materials if you need these clauses. They're pretty lengthy, but you want to put them in. If you have downhole tools, we don't at BJ, but if you do, you're going to want a downhole tools provision. And pollution, and this one? Pollution and contamination. You want to talk about this one?
Yeah, so oftentimes what you see in some of the more well-drafted MSAs is there will be there'll be a separate provision for instances of pollution, whereby the parties take on respective obligations. Usually the operator agrees to indemnify the contractor for below ground pollution, things like that, and it's asking the contractor to indemnify the operator for above ground pollution. Now, depending on how it's written, most of the time we want to redline it, and we want to redline it because we want to narrow the circumstances and the situations in which we're agreeing to indemnify them for pollution. So, generally speaking, my approach is to make it, as you see here, make it so that it states that you're only liable for pollution that's directly emanating from your equipment or property. You have control of that equipment and property at the time such pollution occurs or such discharge of pollutants occurs. And it's only above the land or water. That would be kind of just a starting point. And another thing that you also want to be careful of is ideally, if you're going to take on pollution liability in the form of indemnities, you want to try and narrow that indemnity obligation to the costs of containment and cleanup, and not to other damages like property damages, personal injury, things like that. And how you would do that in most instances would be to make redline the pollution clause and make it clear that it's subject to the other respective indemnity obligations of the parties in the general knock-for-knock indemnity. So the parties are still liable for their own property damage and personal injury of their employees, but you're agreeing to take on control and remediation of the actual pollution in specific circumstances. Yeah. So this is an example of an underground property damage carve-out that we would like to include in every MSA, especially in cases where the general knock-for-knock indemnities have a gross negligence or willful misconduct carve-out, and so you can see that under sub-items 1, 2, and 3. It covers a couple of situations that I think would be considered catastrophic events, as they're generally understood. And this is definitely something you want to have in there. You want to be very sure that when you insert this provision, or if there's another provision like this already in there, it has the notwithstanding any other provision in this agreement language, because this is something that contractors shouldn't take liability for.
Because if they have a blowout, kill somebody, and let them blow.
Absolutely.
This is the number one missing clause in an MSA that we see every day. This is missing on a lot of them, and it gets put in, and they agree to it every time. This is an alternate language that I use. It's basically the same stuff: loss or damage to the formation, loss of property rights or other interest. But I add, or the quiet enjoyment thereof, to those property rights, the land, oil, gas, mineral, all that stuff. And I add subsurface trespass. And the reason that I add those two things is because those two things are really third-party indemnities, right? Quiet enjoyment means I'm going to try to get out of somebody suing us because our frac equipment is too loud. I want them to sue the operator who told me to use the frac equipment in that location, right? They picked the location, they picked what hours we frac, so they should be liable if the neighbors don't like it. So I try to shove that into quiet enjoyment so that they're liable and I'm not. Same thing for subsurface trespass. If they're in control at all of what I'm doing and what I'm putting in the hole or what I'm putting in a water disposal well, then I want them to be liable if someone accuses us of subsurface trespass. And the reason is because there are a couple of cases, or actually a bunch of cases, that talk about trespass, and in Texas, that question is open. There's a fairly recent decision where the Supreme Court was asked, can you have a tort of subsurface trespass with water? And instead of addressing the question, the Supreme Court said, it's still open. So they could have said, no, there's no such thing as subsurface trespass with water, but they didn't say that. And so, I want to take out liability for that every time I can. The quiet enjoyment, you might remember in 2012 to 2014, I think there were a lot of Texas entities like Fort Worth and Denton and all these little towns that were passing all these ordinances basically outlawing fracking, outlawing drilling during particular times and places, and there were a lot of people suing for damages regarding nuisance, whether it was noise or the trucks on their street or you're too close to my property or whatever, and they were suing everybody, including the service companies. And let's face it, we only work because the operator wants us to work. So in my view, that's all a third-party claim that should be on them. So I actually started writing the third-party indemnity language to say the operator has all of it. Because why not? It's their site, it's their location. If it's a third party, a true third party, it's probably one of their neighbors. So make them take responsibility. And operators took that for a while, but then they started writing their own language so that it was more like, we'll take things that we're responsible for and you'll take yours. Anything that your negligence caused, you'll take that. Anything that our negligence caused, we'll take that. So, do we want that? I mean, we take it every day, right? You guys have third-party language in your MSAs, don't you? Who has third-party? And you basically say, subject to our negligence, to the extent of our negligence, we'll indemnify you. Do we really want that, though? Because what happens if a third party sues us and our operator, our customer? What happens under the law? You're only negligent. I mean, you're only liable to the extent of your negligence anyway, right? But if you have this clause that you've just written and you say, we're going to indemnify you, we're going to defend and indemnify you, then when you get sued or they get sued, all of a sudden we now have these burdens of defense, the duty to defend. Do we really want that? I don't know. I personally can live without it. I would rather go at law than have a duty to defend somebody when I'm only partially negligent. That bothers me. So I would go at law, but they're in almost every contract, and we agree to them if the other side wants it. What you really need to watch out for is what they're doing now, which is they put it all on us. And then they say, we'll take it if we were solely negligent. Well, that's not fair. That's not mutual. So usually I can get them to fix that. But if you're just reading the language and you're sort of skimming and you're not careful, a lot of them will say that now, where they'll only take it if they're solely negligent. That's crazy. We don't want that. Okay. Let's go. Fines and penalties. You'll see language like this, that we're going to defend, release, indemnify from and against any claims to the extent that they arise because of our violation of law. And so I started calling the other side, what do you mean by this? What do you really want me to take responsibility for? Because that first paragraph flips the indemnities on their heads again. You know, what if we violated some local ordinance about how late we fracked and somebody got hurt? Well, no. So I have been able to successfully understand that what they really want is they want us to indemnify them for governmental fines. If they get an OSHA fine for something that we did wrong, they want us to pay it. Well, I'm okay with that. So we do this. It has to be a penalty or fine that's imposed by a governmental entity or a tribal entity. Then we'll be fine with that. That's not going to turn the indemnity on its head like any claim. Does that make sense? So I get that every time. Okay. And we have rental equipment and tools. We've got a really nice paragraph for you to insert if you have rental equipment. Do you want to talk about this?
Yeah, absolutely. So, the previous slide brought up a couple of things that, you should, are especially important to think through if these items, or if rental is kind of the essence of your service to operators. One thing that I pay particular attention to, if they do have some kind of rental equipment liability language in their MSA already, which not many of them do, they usually agree to take on some sort of liability, but it's very limited. And there'll be a carve out saying, well, we don't take any liability for loss or damage to your equipment, to the extent that you're negligent, grossly negligent, or, whatever. And I think, if your service is where you take a piece of equipment, deliver it to the drill site, and leave it there for them to use, and you don't have your own personnel operating it, and you have no effective control over it, then I really think that, there shouldn't be any kind of carve out for your negligence because, you can't be negligent. So, you want to pay close attention to how they have this language written if it's already in there. And if it's not, and you're renting out equipment, you definitely want to make sure that you have something along the lines of, this suggested language in there.
Okay, last topic is liens, something near and dear to the Dore group. And so we want to talk about just a couple of different issues with regard to liens. So here's a broad lien waiver. Andre, you want to talk about that?
Sure, yeah. So, watch out for things like this. So if you pay close attention to the second provision here, this language that's in red, as kind of like a baseline, most MSAs will require you to protect the company from and make sure that your subcontractors or material men don't put any liens on their property. Oftentimes, though, now we see that they'll also have some language in there, even if it's just a couple of words, as in this case, where they state that you're not allowed to place any liens on there. Essentially, that's obviously a lien waiver. So, this is language that for a while, we had requested to be inserted in there if it's not already in the MSA. So we're generally fine with them requiring us to protect them from our subcontractors and material men's liens. We're responsible for paying them. most clients will agree with that, but when we get into waiving our own lien rights, we want to make it absolutely clear that no matter how their language is written, we're not waiving our right to file a lien if they don't pay us. And how this has been written, and we see it now in a lot of agreements where they'll have lien waiver language, but then they'll have this kind of carve out for us at the end. And for the longest time we thought that's good. It's acceptable. They're giving us they're saying that we can file a lien if they don't pay us. Well, the issue is if you kind of read it closely and think about it, this last part that we struck through here, in breach of this agreement. Well, as we talked about earlier in the presentation, as you probably know, most MSAs have a provision whereby the operator can dispute any invoice. They get to withhold those funds, and if they dispute the invoice and withhold those funds, they're technically not in breach of the agreement. That's their right under the agreement. And so the logic is, well, they could go and dispute every single one of your invoices if they just don't want to pay you or they can't pay you, and you don't have a right to file a lien. So going forward, we decided that we should just insert this language and just leave it whereby it says simply company's failure to pay contractor. If they fail to pay you, we get to file our lien.
And this is my language that I normally write, which is statutory liens. I use the word statutory because I want to say to them, what do you mean? I mean, it's our statutory right. You want me to waive something that I have a right to by statute? It doesn't make sense. And then lien waivers and whether or not they're enforceable, I think.
Yeah, so this is basically kind of a hot topic, at least for us personally. There's not much case law on lien waivers. It hasn't been really written a lot about, except by a couple of firms that specialize in this area, like us. And so the only case kind of on point so far has been an oral decision of a bankruptcy judge in the Northern District of Texas, which obviously has limited precedential value. But we did want to note that we are appealing this exact issue before the 14th Court of Appeals, and we're hoping to have some positive case law on this point soon.
Okay, I think that just about takes up all of our time. So in the materials, you'll have a jury trial waiver. And that's about it. Oh, limitations. This is another way that they're shifting that risk to us, so I think it's worth highlighting. We have seen MSAs come across that say, no matter what the statute of limitations is, you can't bring a claim against us after X number of days or X number of, usually it's about a year. In this case, any legal action has to be commenced within 120 days. So they're trying to change the statute of limitations. We redline that, take that out. Okay, I think that's pretty much sums it up.